Hospitals, like doctors, owe their patients a duty of care. In Darling v. Charleston Community Memorial Hospital, the court considered that duty's scope. Darling broke his leg playing college football. Dr. John Alexander treated Darling at Charleston Community Memorial Hospital. After Alexander applied a cast, Darling experienced severe pain and his toes became swollen and dark-colored, progressing to cold and numb. Alexander made some efforts to improve the situation, but after 2 weeks, Darling was transferred to a different hospital where the lower part of his leg had to be amputated. The operating surgeon said that gangrene in the leg resulted from constricted circulation because the cast was too tight. Darling's father sued the hospital and Alexander for malpractice. The case against Alexander settled before trial. Darling alleged that the hospital was negligent in failing to exercise adequate supervision and in not requiring Alexander to consult with other doctors after complications began. Darling also alleged that the hospital was negligent in not having enough trained nurses capable of recognizing Darling's deteriorating condition and notifying the hospital administration and medical staff. The trial court allowed Darling to submit state licensing regulations, accreditation standards, and the hospital's bylaws to establish the hospital's standard of care. The jury found for Darling and awarded him $110,000 in damages. On appeal, the hospital argued that the regulations, accreditation standards, and bylaws shouldn't have been admitted because the relevant standard of care was the degree of care practiced by other area hospitals. The hospital also argued that it only owed patients a duty to use reasonable care in selecting medical professionals. The appellate court affirmed. The Illinois Supreme Court granted review.